Welcome to the Deep Dive. Today, our mission is, well, pretty specific. We're tackling a really important Supreme Court decision, a recent one from June 2025.
That's right. It deals with the rights of disabled schoolchildren.
Exactly. And specifically, what level of proof, what kind of evidence parents need when they challenge a school for, failing to accommodate their child's needs. For you, the listener, this is super relevant if you deal with public schools at all, maybe as a parent, an educator, or just an interested citizen. It really clarifies the legal standard for ensuring equal access to education.
And we're looking at the case AJTV Osseo Area Schools. But before we get into the specifics of that case, we really need to set the stage.
Yeah.
Because disability rights in schools, well, they're governed by 3 federal laws that overlap and frankly can be kind of complex. Understanding those is key to understanding this ruling.
Right. Let's unpack that legal landscape then. 3 pillars of protection, you said.
Yes. First up, probably the most well-known, is the Individuals with Disabilities Education Act, or IDEA.
Okay, IDEA. I think most people have heard of that one.
Probably. It's the main law that provides federal funds to states. But there's a catch, a condition.
Which is?
States get the money in exchange for guaranteeing what's called a free, appropriate public education, FAPE, for eligible kids with disabilities.
FPE. I got it.
And the core mechanism for delivering that FAE under IDEA is the Individualized Educational Program, the IEP.
Ah, the IEP. That's the personalized plan, right? Developed by the school, parents.
The student, when appropriate, yeah. It's meant to be a collaborative document outlining the specific services and goals for that child. So IDEA is really about the services, the plan.
Okay, so IDEA provides the specific educational plan.
Right.
But you mentioned 2 other laws.
Correct. These are broader anti-discrimination laws. First, there's Section 504 of the Rehabilitation Act of 1973.
Section 504.
Okay. It essentially says that no qualified individual with a disability can be excluded from, denied benefits of, or subjected to discrimination under any program receiving federal funds solely because of their disability. It's a broad civil rights law.
And the third one?
Very similar. It's Title II of the Americans with Disabilities Act, the ADA. It prohibits discrimination against qualified individuals with disabilities by public entities, which includes public schools again, based on disability.
So Section 504 and the ADA sound pretty similar in their goal.
They are, especially in the school context. They both provide these fundamental anti-discrimination guarantees. The key difference, though, compared to IDEA, is that IDEA is focused on ensuring the appropriate educational services are provided. Its main remedies involve fixing the plan, providing compensatory education, that sort of thing.
Right, fixing the IEP.
Whereas Section 504 and the ADA, as civil rights laws, allow individuals to seek other remedies, including, importantly, compensatory damages money for intentional discrimination.
Okay, so that's a crucial distinction. IDEA for the educational plan and services, 504 and ADA for the anti-discrimination piece, and potentially damages.
You got it. And that ability to seek damages under 504 and the ADA is what brings us to the heart of the AJT case.
All right, let's get into the facts then. This is where it gets really interesting. Tell us about AJT.
AJT is a teenage girl diagnosed with a rare and severe form of epilepsy. Her seizures primarily occurred in the morning.
Meaning she couldn't attend school at the regular start time?
Exactly. She effectively couldn't start her school day before noon. But importantly, after noon, she was alert, engaged, and perfectly capable of learning right up until about 6 p.m.
Okay, so a different schedule was needed, but she can definitely learn.
Absolutely. So in 2015, her family moved to the Osseo Area School District in Minnesota. They went through the process, explained the situation, and asked the district to include afternoon or early evening instruction in her IEP to accommodate her disability.
Seems reasonable given her medical needs. What did the district say?
They refused. They wouldn't provide instruction after the regular school day ended.
Why not? Was there an educational reason?
Not according to the lower courts. The refusal was based almost entirely on what the courts called administrative convenience.
Administrative convenience? You mean like it wasn't convenient for their staffing schedules?
Precisely. They didn't want to arrange for faculty to teach outside the standard school hours. It wasn't about AJT's ability to learn, it was about the district's preferred schedule.
Wow. So what was the impact on her education?
It was significant. Because she couldn't start until noon and they wouldn't teach later, AJT only received about 4.25 hours of instruction each day.
And a typical school day is?
Around 6.5 hours for non-disabled students in that district, so she was losing over 2 hours of education every single day.
That's huge. So what did the parents do?
They fought back. First, they pursued a claim under IDEA, arguing the district had failed to provide her with that free appropriate public education, the FAPE we talked about.
And did they win?
Yes, they did. An administrative law judge sided with them, finding that FAPE had been denied. The judge ordered the district to provide compensatory education for the lost time and, crucially, to start providing instruction from 4:30 p.m. to 6 p.m. going forward.
So they won under IDA, they got the plan fixed.
They got the plan fixed for the future, yes. But that IDA victory didn't address the harm already done. Think about the years of reduced instruction she'd already experienced while this was being sorted out.
Right, lost learning time.
Exactly. So to seek compensation for that harm, for those past damages, AJT and her parents filed a separate lawsuit. This one was under the ADA and the Rehabilitation Act, the anti-discrimination laws.
Okay, seeking damages now.
Correct. And this is where they ran into that legal wall we mentioned earlier, a specific hurdle just for education cases in that jurisdiction.
The Monahan rule, right?
Yes, the Monahan rule. It came from a precedent in the 8th Circuit Court of Appeals, which covers Minnesota. And this rule imposed a special, much higher standard of proof for education-related discrimination claims seeking damages.
Higher than normal. How so?
It required what they called a heightened showing. To win damages under the ADA or Section 504 in an education case, the plaintiff AJT in this instance had to prove the school acted with bad faith or gross misjudgment.
Bad faith or gross misjudgment? That sounds intense. Much more than just making a mistake or even being careless.
Much more. The lower courts, applying Monahan, basically said that even if the Osseo district was, say, negligent or perhaps even deliberately indifferent to AJT's needs and the fact she was losing educational time, that still wasn't enough. It didn't meet the bad faith or gross misjudgment standard required in that circuit for school cases. So her ADA and Section 504 claims were dismissed.
Wait a minute. So outside of schools, if someone faces disability discrimination and wants damages, they don't have to prove bad faith?
Generally, no. In most other disability discrimination contexts across the country, the standard for getting compensatory damages requires proving intentional discrimination. And courts have widely held that this standard can be met by showing deliberate indifference.
Okay, let's clarify that. Deliberate indifference versus bad faith or gross misjudgment. What's the real difference there in practical terms? Is deliberate indifference just like ignoring an email?
No, deliberate indifference itself is still a high bar. It's not just simple negligence or a mistake. It typically means the institution, the school district, in this case, has actual knowledge that its actions or inaction are very likely violating someone's federally protected rights, and it essentially chooses to do nothing about it. It implies knowledge and disregard.
Okay, so knowledge and disregard, but bad faith.
Bad faith implies something more, like actual malice, ill will, or maybe consciously doing something wrong. Gross misjudgment suggests recklessness far beyond ordinary negligence. It's a significantly harder thing to prove.
So disabled kids in schools, at least in the 8th Circuit, were facing this tougher standard than anyone else alleging disability discrimination.
That's exactly the issue the Supreme Court took up. There was this split among the circuit courts on whether this heightened bad faith standard was appropriate for schools.
And the Supreme Court's decision was?
Unanimous. All 9 justices agreed.
Wow, unanimous. What did they decide?
They held very clearly, school children bringing claims under Title II of the ADA and Section 504 of the Rehabilitation Act, even when those claims relate to their education, are not required to meet that heightened bad faith or gross misjudgment standard.
So no special, harder-to-meet standard just for schools?
Correct. They are subject to the same standards as plaintiffs bringing similar claims in other contexts. The court essentially leveled the playing field.
What was their reasoning? How did they get there?
It really came down to the text of the laws and a specific action Congress took years ago. First, the textual argument.
Okay.
The court looked at the ADA and Section 504 and said, look, there's nothing in the language of these laws that suggests the protections against discrimination should apply with lesser force or require a higher proof standard just because the setting is a school or the claim relates to education. The language about available remedies is broad, expansive, and unqualified, as they put it.
Makes sense. The laws don't carve out an exception for schools.
Right. But the historical and legislative argument was arguably even more powerful. It relates back to how courts initially tried to mesh IDEA with these other anti-discrimination laws.
You mean the Monahan rule itself was an attempt to do that? By protecting the IDA process?
Exactly. The thinking behind Monahan and similar rules was sort of trying to prevent the IDEA's collaborative process from being undermined by constant lawsuits for damages under the ADA and 504, so they effectively let the IDEA framework implicitly limit the scope or remedies of the other laws.
But the Supreme Court said that's not right.
They said Congress already decided that wasn't right, decades ago. This goes back to a 1984 Supreme Court case, Smith v. Robinson. In Smith, the court had ruled that IDEA was essentially the exclusive pathway for education-related disability claims.
Oh, so back then the court did say IDEA sort of trumped the other laws.
It did, but Congress reacted very quickly and very strongly. They saw the Smith decision as undermining the civil rights protections for disabled students.
So Congress stepped in.
Yes. In 1986, just 2 years after Smith, Congress amended the IDEA by adding a specific provision, Section 1415.
And what does Section 1415 say?
It's crystal clear. It states that nothing in the IDEA shall be construed to restrict or limit the rights, procedures, and remedies available under the Constitution, the ADA, Section 504, or other federal laws protecting children with disabilities.
So Congress explicitly said, IDEA does not limit your rights under the ADA or Section 504. They operate independently.
Precisely. It was a direct legislative override of the reasoning in Smith. And the Supreme Court in AJT said this Monahan heightened standard, which effectively did limit the remedies under the ADA 504 in school cases, was completely irreconcilable with that clear command from Congress in Section 1415.
So the Eighth Circuit's rule was basically ignoring a direct instruction from Congress.
That's the core of the ruling. The heightened standard had to go because Congress had already forbidden that kind of limitation.
This connects to a bigger picture, doesn't it?
Correct.
About what disability discrimination actually is. It's not always intentional malice.
Absolutely. The court's decision reinforces that. The legal standard in these statutes, the phrase, by reason of disability, focuses on causation. Did the disability cause the exclusion or denial of benefits? It doesn't necessarily require proving an improper purpose or animus, like hatred or ill will.
Right. Discrimination can just happen through neglect.
Through thoughtlessness and indifference, as courts have sometimes put it, through benign neglect, especially when it involves failing to provide reasonable accommodations.
The analogy often used is about architectural barriers, right? Like stairs.
That's a perfect analogy. Think about a public building, maybe an older courthouse, built with only stairs at the entrance. The architect likely didn't design it with the specific intent to exclude wheelchair users. There probably wasn't any malice involved.
But the stairs do exclude them.
Exactly. They exclude people who use wheelchairs by reason of their disability. The impact is discriminatory, regardless of the architect's intent. Now imagine if, to get a ramp installed, the person had to prove the original architect acted in bad faith.
Yeah, that would be almost impossible. Claims for things like ramps or accessible restrooms would almost never succeed.
Right. So this ruling reaffirms that the focus of these laws, particularly when seeking remedies like damages that require showing intentional discrimination met by deliberate indifference, is on addressing the impact of discriminatory structures or policies, including indifference, not just punishing overt malicious intent.
Which means schools can't just hide behind, oops, we didn't mean it, if they were deliberately indifferent to a known rights violation.
Not anymore, not without facing potential liability for damages under the ADA and Section 504, judged by the standard of deliberate indifference, not bad faith.
So what happened with AJT's case specifically?
Well, the Supreme Court didn't decide whether the Osseo District was deliberately indifferent. They only decided the standard. So the judge under the Eighth Circuit, which had dismissed her case based on the heightened standard, was vacated, basically nullified.
And the case goes back.
Yes. It was sent back down to the lower court, the Eighth Circuit, with instructions to reconsider her ADA and Section 504 claims using the proper standard, deliberate indifference.
Okay, so wrapping this up, what are the key takeaways for our listeners? For parents, educators, anyone involved with schools?
I think the biggest takeaway is clarity and reinforcement. This ruling makes it absolutely clear that the civil rights laws, the ADA, and Section 504 stand strong and independent alongside IDEA. They aren't weakened just because the context is education.
So if you're a parent navigating the special education system, you potentially have multiple avenues, multiple tools.
Yes, IDEA provides the framework for getting the right services and educational plan put in place. But if there's intentional discrimination, if the school is deliberately indifferent to your child's federally protected rights under the ADA or 504, causing harm, you now have a clearer path to seek compensatory damages without having to meet that impossibly high bad faith standard that existed in some places.
The bar is lower now, back to the standard applied everywhere else. Still requires proving deliberate indifference, which isn't easy.
Still requires proving deliberate indifference, absolutely. This isn't about opening the floodgates for minor disagreements. It requires showing the district knew, or clearly should have known, they were substantially likely violating rights and they failed to act reasonably. Documentation becomes key.
Right. Showing that pattern of knowledge and inaction. It's still a fight, but maybe a fairer one now.
A fairer fight, exactly. The rules of engagement are now consistent.
Okay, final thought then. The court clarified the standard for intentional discrimination needed for damages is deliberate indifference, not bad faith. But it leaves a question hanging, doesn't it?
It does. What about situations where a school's actions, or lack thereof, are driven by that administrative convenience we saw in AJT's case, but maybe fall just short of provable deliberate indifference?
Yeah, like systemic issues, maybe thoughtlessness or bureaucracy that still result in kids losing out, but perhaps without that clear knowledge and disregard the standard requires.
Exactly. How much unintentional indifference, how much systemic friction based on convenience rather than student need are we still tolerating? This ruling fixed a specific legal standard issue, but it makes you wonder how much further we need to go to ensure schools are truly proactive about accommodation, not just reactive when facing potential lawsuits.
Something important for everyone involved in education, and from parents to policymakers, to think about. How do we move beyond just meeting the legal floor?
That's the ongoing challenge.